First, I'll assume that both the husband and the wife know that the child is not biologically his, and that the husband and wife did not adopt the child. This is a complicated situation since Florida law states that children born during a marriage are the legal children of the husband. As a result, if the parties divorce, the court must determine a time-sharing schedule and establish a child support amount. In most of the cases that I've handled where this situation arises, neither the husband nor the wife expects or wants the husband to pay child support for this child. The problem is that the judge has very few options. In order for the husband to avoid a child support obligation, he must have his legal rights to the child terminated. This can only be done if the court finds that the termination of parental rights is in the child's best interests. To show that the termination of parental rights is in the child's best interest, the biological father needs to file an affidavit of paternity in the husband and wife's divorce case. This affidavit needs to state that he is the biological father and that he intends to assume the role of father in the child's life. Similarly, the husband needs to file an affidavit of non-paternity where he states that he is not the biological father of the child and that he does not wish to assert his legal parental rights over the child. Lastly, the divorce order itself needs to state that the parental rights of the husband are terminated. This termination, however, does not establish the legal rights of the biological father. This whole situation is greatly complicated if the biological father can't or won't sign an affidavit of paternity. Essentially, the court will not allow the child to be legally fatherless, so the husband may be forced to pay child support. This situation is also greatly complicated if the husband does not want to give up his rights to the child.